individual's will is a disposition made by them that only takes effect after his death, wherein he or she typically gives pointed directions to direct executors on how they should distribute their possessions after their death. Although there is a lot of mistrust surrounding wills, when they are prepared legally, they are helpful in the administration of a deceased person's assets. One of the main advantages of creating a will is that the executors can divide the deceased estate according to the terms of the will without intervention from outside parties once it has been proven that the will was lawfully made and accepted to probate. On the other hand, not having a will makes it simple for some people to illegally meddle with an estate's assets, especially when it comes to determining how the estate should be divided. These people include the deceased family, those who should have been the beneficiaries of the will, assuming one was made, and mischievous third parties. Parties who have any reason to doubt the legitimacy of a will that may have been allegedly drafted in an attempt to divide an inheritance among the listed beneficiaries, and in some situations, the will's executors, are among the main causes of the estate disputes. Creating a will is the first line of defense in the event of a dispute, even though it does not necessarily ensure that one will not occur. At this point, the matter to be resolved is whether the will was legally valid or complied with. A will is a legal document that allows a person to specify what will happen to their possessions when they pass away. It also helps someone like that to leave instructions about his assets once he passes away. Therefore, a will is just a representation of a person's goals and desires that are to be fulfilled in their memory. A will is an act of legislation, and as such, it must be subject to the terms of the applicable statute. Requirements of making a will. It must be in writing. It is signed by the testator or signed by the testator's name by some other person in the presence and by the direction of the testator in such place on the will so that it may be apparent on the face of the will that the testator intended to give effect by the signature to the writing signed as the testator's will. The testator makes or acknowledges the signature in the presence of at least two witnesses present at the time. The witnesses attest and subscribe to the will in the presence of the testator, but no form of attestation or publication shall be necessary. Section 4, subsection 1, Will's Law of Legistate covers this. Succession. The transfer of property to individuals following the death of the property's owner is known as succession. Now, this concept has a legal consequence that the deceased individual leaves to his or her successors not only the property but also the legal rights and liabilities associated with it. Both statutory and customary laws govern inheritance and succession. Testate succession refers to a state of affairs when an individual dies and leaves a will behind to govern the distribution of their property, while intestate is the state of affairs where the individual dies without making a will to govern the administration of their property. Both testate and intestate succession are governed by laws that have been passed by legislatures in developed nations like the United States and the United Kingdom. In Nigeria, intestate succession is governed by diverse Islamic and customary laws among the many ethnic nationalities, whereas testate succession is governed by the Wills Act, state wills laws, and administration of estates legislation. Only Muslims in the nation are subject to succession regulations under Islamic law. Approximately 500 separate ethnic nations make up Nigeria, and each has its own unique local law, custom, or personal law that governs property, succession, and inheritance. Some of these laws, however, still conflict with natural justice, equity, and morality in the 21st century. Now, the majority of Nigerians live in rural areas with high rates of poverty, lingua franca impairment, limited reading and comprehension skills, and many other socioeconomic inequalities that impede legal actions against discriminatory practices in the distribution of their ancestors' property. Now, the country's literacy rate is still low. Only a small percentage of wealthy, intelligent people who are willing to safeguard their benefactors and heirs after death execute wills. The laws, customs, and local law that govern testate and intestate successions and inheritance in Nigeria clearly differ from one another. Rules of succession among the Igbos. Primogeniture, a succession by the first male child, known as Opala or Diopala, is the main principle, even though there may be minor variances in inheritance and succession laws throughout Igbo ethnic groupings. The patrilineal system serves as the exclusive foundation for the primogeniture concept. Therefore, the first male kid takes over the family's head upon the death of the family's founder or head. He receives the immediate neighborhood, his father's leaving house or obi, as well as a single, distinct plot of land known as Anisiobi. As a family, other sons, however, get the properties and lands. According to the Igbo customary law, women, daughters, or widows have no right of succession or inheritance. According to the Supreme Court, however, customs that force a daughter to give up her father's or her husband's belongings are against natural justice, equity, and good conscience and should be outlawed. Anikwe versus Inuekwe, 2014. Rules of succession among the Yorubas. Unlike the succession system in Igbo land, both the deceased male and female children are eligible to inherit under Yoruba customary law on succession and inheritance. Children, both male and female, who are legitimate, share their father's properties equally. Nonetheless, Daudu, the eldest male child, is inherently in charge of overseeing and managing their father's estate as he passed away. Now, the case of Lewis versus Bankole in 1908, which established the following Yoruba laws of succession, provided judicial approval for the basic Yoruba native law and custom on inheritance and succession as follows. The oldest living son, known as Daudu, takes over as head of the family home and handles family businesses upon the death of the family's founder. The next oldest son, surviving child of the founder, who may be the male or female, takes over as the family's leader after the death of the eldest son. Before the family's property can be alienated, all branches of the family or representatives in the family council, that's the children of the deceased many wives, must be consulted and their approval secured. The offspring receive the equal portion of the property regardless of the family branches. The grandkids of the deceased founder are only eligible to inherit once their parents pass away. The original home or compound is conserved. According to Yoruba native law and custom, there are two main methods for dividing a deceased man's estate: per stripes, also known as idigi, and per capita, also known as Oriojuri. Rules of succession among the houses. Islamic law of succession. The Prophet's enumeration of Islamic or Quranic teachings is the foundation of the concept of inheritance in the house of land. Islamic jurisprudence does not recognize joint tenancy, and the successors are tenants in common, meaning they are only eligible to inherit the shared portions of the property. But under Muslim law, inheritance is not a birthright. Rather, it is not guaranteed to every child born into the family, and a parent heir must live after the deceased in order to inherit. As long as the unborn child is alive, it can also inherit while still inside its mother's womb. The child's vested portion of the property is forfeited in the event of stillbirth, as the child will be regarded as if it never existed. Both male and female heirs are entitled to inherit property under Islamic law within the heir class. Cognates or near female heirs are acknowledged. Now, however, under the Islamic system, women will receive more wealth through mere upkeep and their maintenance given by their husbands, whereas men only have inheritance, which helps them fulfill their obligation to support their wives and children. As a result, women only receive half of quantum shares allocated to their male counterparts. However, in the married relationship, each spouse has an equal claim to inheritance from the other. A widow is covered by the inheritance plan. If a widow is childless, she receives a quarter of her deceased husband's property. If she is a grandparent or has children, she receives an eighth of his estate. In contrast, a widow should not be entitled to inherit if she married a Muslim man when he is ill and that marriage was not consummated as a result of the marriage's circumstances. However, her ability to inherit remains unrestricted until she remarries if her spouse filed for divorce before she passed away from illness. By designating them as the intermediate heirs or first in line to inherit, Islamic laws likewise grant precedence to the deceased ascendants over the descendants in the inheritance arrangement. Two categories of successors are recognized in the Islamic inheritance system: the residuaries, also known as conversional heirs, and the shahers, or Quranic heirs.